Good afternoon, everybody. This is Lisa Speaker. We're here today for child support issues during the COVID-19 crisis. I have a great panel with me today, starting with Kent Waichman, who is now in private practice. He used to be with Wayne County Referee's Office, and before that he was in private practice. But one of the main reasons he's here today is because he has been on the Child Support Review Committee since pretty much the beginning of time. And so he's seen lots of revisions and been very highly involved with that over the years, and has a lot of insight into what the formula says and means. And we next have Paul Game. He is a management analyst at the State Court Administrative Office. He's been on the Child Support Review Committee for the past 2 seasons. So the committee convenes every 4 years to do the review. So he's been on that committee for 2016 and for the 2020. And we also have Erin Magley, who is a referee with the Ottawa County Circuit Court. And she is, one of the things she does is child support reviews and hearings. So thank you, panel, for being here. I think we're going to start off today by having Kent address everybody about the dilemma that parents and their attorneys are facing right now. And then he'll be able to turn it over to Paul to share some updates about what's going on right now with the courts. Kent?
Right. I mean, there are 2 issues that people confront right away. One is if you have an order that's too high and you're trying to get it modified, this is a really tough time to get in for a modification. On the other hand, you have to, because if you wait, the arrearages build up and you can't modify them retroactively. That's 552-603 prohibits retroactive modification of orders up until the point you give notice to the other party that you're asking for a modification. So until you do that, until you file a motion and provide notice to the other side, your support order is still running and can't be modified. And for other people, the problem is if there is an income withholding in operation and your wages are reduced, that income withholding is going to go right up to the 50% mark, which may be far more than the person can afford. So one thing is, how do you get temporary relief, something right away to avoid that situation? And another issue is, how do you prevent the arrearages from building up if you don't get something modified right away? If someone, for instance, is off work completely, the income withholding isn't working, so you can say, hey, what's the problem, right? No income, no child support's being withheld, but the arrearages are building up. So those are 2 issues that have to be addressed at a time that the courts are struggling to make it possible to file motions.
And Ken, isn't it, I mean, based on your comments, isn't it true that the parent who actually is still working but has reduced hours is actually in a worse situation? Because they're going to have a lot less income coming into the household, and more of it's going to be taken up by child support.
Well, because the income withholding will keep operating right up to the 50% limit. So if normally you're only paying 25% of your income in child support, if your hours are reduced, that same amount, it's not based on a percentage, that's whatever the order was, will continue to run. That's what's going to be withheld, unless that goes up over 50% of what your earnings are.
And just to let everybody know, before I turn it over to Paul, we're hoping to talk today about modifying support, on the mechanics of getting it modified, and also what qualifies as income. And there's so many different wrinkles and angles to look at here. So Paul, why don't you give us a little update as to what we hope to see from the Supreme Court at some point to give us guidance on child support?
Yeah, so we've certainly been aware to a lot of these issues and have started working on several different publications to communicate, identifying the issues and presenting some ideas on how to address those issues. We've already published an FAQ through the Front of the Court Bureau on parenting time and custody questions and answers. We're working on a support one as well. We've got a couple other publications that we're working on to help address issues like the retroactive modification piece that Kent already referenced, and providing relief to parents during this, really difficult time. One of the other issues I know we're looking at as well is in relation to the school closures and the parenting time and support issues surrounding that executive order as well. So we're aware of the issues. The Supreme Court is aware of them and is considering what to do in answering and addressing those.
Excellent. Well, let's just jump into talking about the Rev Mod product, the review modification process, and how do we get, one, if there is a need to change support because the person has lost income or has reduced income, how do we get them into court to get a modification? Because filing the motion, that's all fine and dandy that the notice is going to be at some, maybe cut off at some point or is the date you file your motion, but filing a motion doesn't actually change your support obligation. It might help you down the road with arrearages, but it's not going to give you the relief that a parent needs right now if they have no income or reduced income. Kent or Aaron?
So one problem, there are a number of ways to get your support modified. You can file a motion either in pro per or have your attorney file it for you. But the other way that many people get reviews is they request one through front of the court, and that's under 552, 517, or 517B. And the front of the court, when it gets these requests, will do a calculation of child support. Some offices do that by getting information from wage reporting. Others will give notice to people and ask them for information. But that process takes some time. And until they're done with their calculation, support keeps running. No notice is provided to the other party up until the date you've actually made the recommendation on what the new support should be and sending it out to the other party. And so in the meantime, if someone has a very high support order, those arrearages will build up and can't be retroactively modified up until the point where the front of the court has gotten to that request and has had an opportunity to make their recommendation. So that might be, depending on how busy the office is, might be 2 or 3 months.
Wow.
I know that there are some friend of the courts are working to kind of help parties. I mean, friend of the courts understand the difficult situation here, and they're trying to find ways to expedite those reviews. I know in Ottawa County, we've got a process where we're trying to be cognizant of the effective date problem and give people an opportunity to get notice to the other side that they want a support change as soon as possible, so that the front of the court review process can go forward with everybody knowing that, yes, support is going to be modified, and give them an objection period for a review, but it would still go back to the date that everybody had noticed support would be modified. But I agree with Kent, the safest thing, if your clients need a review, is to file a motion, and then you preserve your date. You have more control over when that date is, how that's determined.
Yeah, I agree. And like Kent said too, I mean, it doesn't result in the order being changed immediately, but you've at least locked in and preserved that date.
And I guess we don't know yet, but I mean,
especially in jurisdictions that have e-filing for domestic relations, the attorneys can get that filed remotely very quickly. If there are all those, I mean, most friend of the courts make available the motions that you can file in pro per, but I think a pro per client is going to have a lot of trouble figuring out how to get that filed, especially during, I mean, many courts are really restricting the ability to get into their clerk's office. Some of them are saying really only for emergency motions, things like that. So I think it's going to be hard for people representing themselves to do that. But if you're in a county that does e-filing for attorneys, actually it won't be that hard to at least get the motion filed and served on the other side, because you only have to serve it by mail. Post office still working, right? So we're in good shape that way.
And there's a lot of courts also, Kent, that are allowing now email and fax filing. So I mean, an improper would have to, just like an attorney would have to look up each specific county. Some websites are better than others about keeping the public informed about what's actually happening. But we as attorneys are getting lots of emails from various counties around the state telling us what's going on in their courthouses. And if they allow it by email, that makes it easy even for an improper. What about the overnights changing? You know, like someone, you know, a parent may not be getting as many overnights because of the concern of doing parenting time exchanges. Do we just assume that at some point they're going to get the makeup parenting time, so we're not going to hold it against them right now, make them pay more support, you know, based on their actual overnights being less than what were ordered?
Yeah, I think one of the concerns that we always have is parents making their parenting time decisions based on how it might impact the child support. And the court never wants people to do that, to be afraid to forfeit parenting time or adjust parenting time during the state of emergency because they're afraid how that's going to impact their child's support. So I think that courts and parties should be cognizant of the fact that this is an unusual time, and it's a careful balance between we may need to provide extra support to the parent if they suddenly have the children a lot more time than the support order anticipated. But I think when we're talking about in your previous webinars about parenting time, I was so pleased to see so many people taking the approach of, we're going to try to make this up, we're going to try to even out the parenting time, and if that happens, we'd be looking at annual overnights. But there are those cases where that might not be possible to do, and I think it's important to look at the equities of what support do the children need, and did that change over the course of 2020. But everything's going to go hopefully back to normal at some point, and we're looking at long-term child support issues and changes.
Yeah, and I think the importance here too is in the formula with, you know, what Kent and the review committees in the past have done is they recognize the need to balance that out over the entirety of the year. It's parenting time offset is applied annually and figured annually. And so by doing that, then, you know, the whole purpose is to ensure that money is following the kid and providing the ability of the parent who has the overnight to provide that overnight. Because circumstances are changing here, you know, I think, you know, you would need probably around a 21-day overnight difference before you really start to see an impact in the support amount. And as Aaron mentioned, and in the call last week, you know, I think until the parenting time order is, or the support order is adjusted, the whole goal is to make up that parenting time once things are normalized again.
The other problem,
I'm
sorry.
Go ahead.
One of the problems with child support is the child support order runs into the future. So whenever you're calculating child support, you're really making a prediction of what the arrangements are going to be in the future, what the income is going to be like in the future. And this is a time when it's really difficult to predict the future. Nobody really knows what's going to be the progression of this epidemic, how it's going to affect people, whether people will be able to get their makeup parenting time, any of those things. Again, with the non-retroactive modification, you can't go back and say, hey, we thought this was going to happen, but it didn't. And so now it turns out that order was unfair. It's too late. And you hate to put people in the position where they have to file a motion just in case, right? That, yeah, we think he's going to make up the parenting time, but if he doesn't, then I'm going to be bearing all the expenses for our children when that wasn't what the order was based on. And that's a little bit awkward.
So one of the questions from the audience has to do with whether you can file a motion to modify child support at the same time as filing a request for review, and then basically just withdraw the motion if you do get a revised recommendation. Personally, I think the answer is yes, but I would love to hear what the panel has to say, because I'm not sure which one's going to, maybe you can also share some insights about which process will be faster. I'm not sure I know the answer to that either. Erin, do you have any thoughts?
I'm not sure I know the answer as to which will be faster. I think it really depends on the counties. Every county, you know, is able to respond differently, just depending on whether we have e-filing, whether we're fully staffed or working from home. I know that, you know, Wayne County has a lot more restrictions because they have so many more. It's not safe, as safe for staff to come in and do hearings, and may not have the ability to work from home as much. So there are different counties that are going to respond differently. I don't think you can't file a motion and have your review process. I think certainly the safest way to preserve your date of notice is to file your motion. And if the friend of the court proceeds with the review process, they may not do that review process if they see that a motion has been filed. They may, you know, terminate any review process that had begun. So I guess it depends on what effective date you prefer to have used.
Right. And I also understand that the friend of court has 180 days to do a review, so that because of statute, so that might mean that normally a motion would be faster. But I guess maybe the bottom line of the question is, why not do, I mean, is there a reason not to do both and just see how it plays out?
Well, and I think what I understood the question to mean was, if you file your own motion and provide notice to the other party, does that give you your effective date? So you file that motion, the front of the court takes 3 months to do its review, but when they finally do the review, will the effective date be back to the date of your petition rather than the date that the front of the court completed its review? I'm not sure. I mean, because the statute does say, retroactive modification of a support payment is permissible with respect to a period during which there is a pending petition for modification, but only from the date that notice of the petition was given to the payer of support and recipient. So, I mean, technically, you could make an argument that even if you dismiss the petition, you did provide notice, but I think it's a little bit risky. I think there are a lot of courts who are going to say, no, that only applied to the petition. Once you dismiss the petition, you lost that review date. You might be able to convince them otherwise, but I think it's a pretty risky proposition.
I would agree with that.
Go ahead.
And to go off of Aaron's point too about you could still file both. I think under statute, parties have the right to a review, to request a review once every 3 years. And so if a party has had a review within the past 3 years, you know, an office might look at that and say, well, you already had that review, so you're going to need to file a motion. Now you can get additional reviews for a substantial change of circumstance, which I'm sure many will fall into during this time. But that could be a reason why you might not be able to file a review through the front of the court and would need to go with a motion.
So there's been several questions on the chat about childcare cost, and for a lot of people, the childcare, they're not using childcare anymore. They're not able to use childcare. Some childcare facilities are open, especially for people working in hospitals. But for example, one attorney has a case where the childcare is insisting that they continue to make childcare payments to hold the spot. I'm guessing it's for a younger child that maybe it's harder to get into for infants and whatnot. But yet the parents' incomes have gone down to basically nothing. So I didn't, how do we deal with the fact that now, the judgment tells us how to deal with childcare, and now the childcare costs have dramatically changed? And is there a way to get in faster? Is there a way to make a change to the support without a motion? I think the answer is no, but please tell me if I'm wrong.
Well, all of the uniform child support orders have a provision that requires the recipient of the child care contribution to notify the friend of the court if those charges stop. And my understanding then is the friend of the court will automatically, without a motion needing to be filed, be able to stop the child care. So that would be in the case where a parent is no longer working, they're no longer paying child care. They have a window there that they are ordered to notify the other party and the friend of the court that those charges have stopped. So you can get relief without filing a motion in that way. But if the child care expenses have increased, the best way for someone to, again, we're back to that effective date issue. The best way for someone to get a fair review and preserve an effective date back to the date that the child care increased is get your service on the other party, give them notice that you're asking for an increase in the child care contribution. And then even if it's not heard for a month or two, you will eventually get back the contribution from the other parent.
Erin, I'm not sure if all offices are doing the same thing, automatically adjusting. It may be that you've just notified the other party and then they can make a motion. But I'm not, if we have front of the courts on the line, they might be able to comment on their practice.
That's a good point, because every county interprets these things differently. And I know that all the orders require you to notify the friend of the court if the charges stop. I guess I don't know what other FOCs are doing when they get those notices.
If anybody, I know there's a lot of referees on the call and some judges. If you're willing to share what your county is doing, please go ahead and raise your hand. And we'll be happy to hear from you about your specific county. So you told us what they're doing in Ottawa County. Nobody's volunteering. That's okay. All right, I wanted to spend some time. Pardon?
Kent might have information about Wayne or Washtenaw FOCs and how they, because you were at both of those. I don't know if you know.
I have to admit, I don't know what they're doing now.
Okay.
But
I will tell you that during the Great Recession in Macomb, they had a procedure that, and Amanda Cole I see is on there. So Amanda, please jump in and correct anything I'm about to say. She's one of our FOC referees. They had an expedited procedure where you didn't actually had to file a motion. An individual could contact the friend of the court and say, basically, I've lost my job or whatever. And so it didn't require the formality. And it was great. And the other counties I practiced in, they didn't do that. But in Macomb, it was great that that was done. And I think that that would be really helpful at this point to be able to do that. My thought is some of the counties I practice in are electronic. Some of them I'm having to mail things in, but I'm about to see whether I'm basically going to file motions to be able to start that process to get the date that we talked about.
So Barbara, I wanted to ask you a question. If for counties like Macomb that are just allowing the parent to notify them of a change, then is there somebody at the friend of court who's then recalculating support based on the adjustment? And I'm assuming there's some sort of like if the other parent doesn't believe the information that's being shared is accurate, is there an opportunity for them to say, well, no, he doesn't have his job now, but he's doing all this other stuff and to earn income or whatever the case is?
Actually, what I was saying was back in 2008 in the Great Recession, that was a procedure they used then.
Not now.
And I'm not sure that that's something that they've used recently, but that's something that was used then. I thought it was great. It saved the clients a ton of money and it was much faster. They didn't have to go through attorneys to do it, but I don't know whether that is still in place. It just hasn't been used in a while or whether they're going to bring it back. I don't know.
Well, and I think the key difference now is the safety issue. And so many of the court staff are not in office, or you've got very limited staff in office. And so the processing that was a little more expedited in the past can get backlogged very quickly today. So that's where, again, filing the motion will at least preserve that date for you. As Erin said, it's back to that effective date issue. So.
Right.
And
go on, Erin. I'm sorry.
Well, I was just going to get back to the original question, which was about payments to hold a spot in the daycare facility, and courts can consider that as childcare. I'm not saying they will, but generally, any cost to maintain a spot, I think they'll try to look equitably at what were your options at that point. Did you, were you really going to lose your opportunity to have childcare for the child if you didn't continue to pay, and whether or not it was reasonable, because under the child support formula manual, the childcare has to be reasonable. So I think those are all factors that would be looked at. But the key is file your motion, preserve your date, and then the court can look at those issues and decide whether or not that is a reasonable expense. But it is permitted to be considered as a child care expense under the formula manual to hold a spot.
Mm-hmm.
Amanda Cole, I think you had something you wanted to share with us.
Yes, I just wanted kind of to play off what Barb had said. That process that she's talking about is no longer in effect. We call those passes, a petition for an adjustment of support. But what we've been doing now during this COVID-19 crisis is anybody who is now unemployed and collecting unemployment or nothing is allowed to send in an email, a fax, a phone call, and we have initiated reviews through our support department pursuant to 552.517. The only thing bad about that is if people are not in agreement to agree to a modification on a temporary basis, and then maybe have another review down the road, then it's going to have to be held by hearing with a referee to address someone's objection. The second bad thing about doing it under the statute is that our support investigators are using the first of the month when they do the review. I'm not sure if they're going to do now give the people the retroactive date of when they send in. I've been laid off as of March 15th. If they're going to use the March 15th date, or if they review it in April, they're going to use April 1st as the effective date. So I can get information about Macomb's process for everybody and put it on, a question and answer for you later. But that process is moving. They're doing them remotely, and we're going to see how many objections we get to see how many referee hearings we get.
Thank you, Amanda. I know, Camille, can you tell us what Oakland County is doing?
While Camille gets on, or unmutes herself, I'll just, I don't know if I mentioned it, but Ottawa County does have a expedited or a streamlined fast track RevMod process. And they're trying to get as many people relief as quickly as possible through the friend of the court, and all the friend of the court staff are still working from home and available. So that's an access point for people. And I did want to step back to give you the formula manual site that mentions the holding a spot. That is 3.06A3 in the manual, references that requiring payment to retain a slot may be included as a child care expense.
Okay, thank you. Camille, you were going to share Oakland County's process right now? I see she's not muted, but I don't know why we're not hearing her. Maybe she doesn't have a microphone on her computer. So Camille, why don't you do this? Why don't you type up something in a message to everyone so we can read what Oakland County is doing? And then while you're doing that, I was going to move to the next topic of conversation, is what sources of income we should be including for parents. As you know, even though a lot of parents don't have income, their normal job income, or have reduced income, there are other sources of income that are becoming available to them. We have obviously unemployment insurance through the state of Michigan, and I'll let the panel talk about this more. But there's a federal program for unemployment. There's other things out there right now that may help alleviate the fact that parents are not able to work right now. Kent?
So, I mean, one thing are the rebates that are available, where we're talking about, I think, $1,200 for a single person and $500 for the child. Clearly, whoever receives that, you can either look at it as less tax paid, which means you have more net income, or just count it as income. Either way, it's going to be part of your income. One question I think we had seen was, well, will the $500 that you get for the child be counted as child support? And I think the answer is no. No, that's just income to the parent who receives it, and then you run the child support calculation based on that.
And I think there's some debate about whether that's going to be treated as income for the parent who receives it, because it's hard to know now, before it's been paid, who it's going to go to. I've heard things like they might base it on the 2018 tax returns. They might base it on if you got your 2019 taxes filed by a certain date. They might base it on who claimed the child there. So if parents are alternating their dependent tax exemption, it could create some lack of predictability on the court's part as to who's going to even get that. So until it's been paid, we don't really know. And I've also heard things that it might end up being more like an advance on a tax, you know, it may not just be like getting cash. So I think there's so many unanswered questions about what that stimulus check is going to look like.
And those stimulus checks have not been sent out yet, have they?
They're starting to be distributed, and I think the expectation is that, I mean, direct deposits are going to happen first, and I think the expectation was April 15 was when you would potentially start seeing that first wave. As to Erin's point, yeah, we're learning more about this every day and the specific details of it. The latest is what she said, that this is really being treated as an advance on the 2020 tax year, and it's an advance on a refundable tax credit. So under the formula manual, we have other refundable tax credits that we identify and that we specifically say would count as income. And as to the child's portion, like Kent was saying, you know, I think generally speaking, you're going to see that the parent who receives it is, you're going to count that as their income. And to Erin's point, to the extent that they're flipping the, you know, the dependency credit year to year, you know, I think that's something that's kind of going to be a little bit of a nuance and a tricky situation. So whether it counts, I think the answer under the formula is yes. How to count it, whether you're going to count it as income only during this period of emergency, or whether you're going to balance it over average it over the course of the entire year, because it is in advance on a tax year. I think you could make a case for both, and I think that's going to be up to the discretion of the court on how specifically they're going to count it.
So let's address specifically the pandemic unemployment assistance. That's the federal money that's in addition to unemployment from the state of Michigan, correct? I heard it might be $600, or do you know anything about that?
So there's the standard state unemployment, and then there's the federal government under I believe the CARES Act has supplemented the state unemployment rate by adding in an additional $600
a week.
As a week, yes.
Okay.
And as I understand it, so I forget what the state rate was, but the standards for eligibility have relaxed. I don't think that you're required to prove that you're actively looking for work, because there's not a whole lot out there other than stocking shelves at Kroger and Meijer. And I know in relation to, I think it's the federal portion, the $600, I think you simply have to self-certify that you were laid off as a result of COVID-related employment issues. So there's a lot of additional income coming in through that unemployment. You know, we currently under the formula do count unemployment income as income. So to the extent that they're approved and eligible and receiving those benefits under the formula manual, they would count.
But just to clarify, Paul, it's my understanding, and correct, I mean, let us know what you understand, because I'm not sure. I think there's so many unanswered questions. That amount, you're not going to get 600, that it is based on your earnings, based on your last quarter. They'll look at things, and this isn't, I think some people have interpreted this as everybody's check is going to be bumped up by X dollars. And what I'm hearing in court hearings from people who have been laid off, they were denied because they didn't earn enough in the last quarter. So they're still looking at some of those things. Part-time employees have been denied. So I think it's really uncertain, and hopefully we'll know a lot more once those start getting paid and granted.
Yeah, and I know I've seen, just today I saw a report that talked about how the state's unemployment rates are generally based off of work history, work hours, that kind of stuff. But the $600 federal portion, according to the article, was a flat rate. And so, you know, it's still so fluid that I think, and this is where, and we'll get into it again later, I think, but the advantage of getting something before the court now to preserve the date and then using a temporary order. is a way where I think we see it often in the front of the court world and referee world for pending social security benefit applications, where you get that in now, you keep it temporary, and under the retroactive modification statute and court rules, the temporary orders are allowed to be modified back. We can get into more of those details later. But that's where here, especially as we don't know whether you're going to get that unemployment benefit and to what rate, a temporary order can be effective.
Right. As Paul says, the 552-603, which is the provision that prohibits retroactive modification, the next section says, this section does not apply to ex parte interim support order or a temporary support order entered under Supreme Court rule. So if you make this a temporary order, then you can go back later and fix it, right? You say, here's our best guess. Everything's uncertain now. We don't even know what benefits people are going to get, but here's our best guess at what appropriate support is. But we're doing this as a temporary order. And when they say under Supreme Court rule, the 3207 is the court rule on temporary orders. And section 4 of it says, a temporary order must state its effective date and whether its provisions may be modified retroactively by a subsequent order. So if you do this by temporary order, you need to put in and intend that it can be adjusted and corrected later. Then you should put in the temporary order itself that this order may be retroactively modified.
Yep, exactly.
So our last two questions. I'm trying to see, there's somebody that's unmuted that there's some background noise. I'm trying to make sure that only the 4 of us are unmuted right now. But the last two questions relate to each other. Brandy Thompson asked about whether the tax stimulus refund check that's coming in will be able to be diverted for paying child support arrears. And then right after that, Tony McDowell made a comment about how it's going to be treated the same as any tax refund. I think that means the answer is yes, that if it's being treated as a tax refund, if a tax refund could be diverted to pay for child arrears, that then the stimulus check could also be diverted to pay for arrears. Do any of you want to comment on that situation?
I did see something on the rebate that they wouldn't withhold federal debts. So I don't know if this would be considered one of the debts that they would normally withhold for, but and I haven't seen the exact language of the actual directive, but this said that out of the $1,200 additional rebate, they weren't going to withhold federal debts. The intention was all the money would flow.
My understanding is the CARES Act exempts or allows interception of this for child support purposes. Okay. So that it's different than other debts that are not going to be intercepted for, but the child support specifically will be if that case is already flagged by the friend of the court in the system to intercept tax refunds. If it wasn't flagged, flagging it now is probably too late.
Got it. Now, you had made a comment, Erin, yesterday when we were talking about the benefits of looking at the big picture. Do you want to share your thoughts about what we're going to be facing, not just for the next month, but for the next 8 months with all the modifications and requests?
Yeah, and I think, Paul and Kent touched on that we're trying to do something temporary now. This is an emergency, and we're trying to do our best to give some relief to both sides. We've got custodial parents who are struggling and need to provide for the kids, and we've got payers who have changes in income, and we won't know the big picture of what their annual situation is down the road. And that's why I think that temporary order and making very clear in item 13 of your uniform child support order that this is intended, putting everybody on notice, this is intended to be temporary. We can adjust this if our estimates are wrong, if somebody didn't get that unemployment benefit that they thought they were going to get, or if somebody got some grant as a small business owner or something that they didn't know they were going to get, so that we can preserve that effective date, go back and look at the overall picture and set the correct amount of support going forward.
So my question is, it's great to be able to do a temporary order. Is there a way to have, and I think there, maybe that's a yes or no question, but is there a way to make it so that if X happens, then it's going to go back to a certain level so that you don't have to go back to court, go back through the waiting process of getting fixed before, when there's, there might be multiple changes that we go through in the next few months as well.
And that really depends on what you put in that uniform child support order. So if you want, I know that our friend of the court is in most cases going to do an automatic reinstatement of the previous amount once the emergency is over. That might not work for some people. So they may be out of work longer term. So it really, if you're filing a motion or you're drafting a stipulated or consent uniform child support order, you want to be very clear what the intention is in your item 13 to say, and I can only speak for what our county would do, but we encourage people to say in there, effective upon the payer's return to employment, or what the effective condition is. And then the burden would be immense on friend of the courts to have to pay attention to all those provisions. So I try to put in there a sentence that says the parties are responsible to notify the friend of the court that this impacts their support charges and their order basically changes. So you can put a second grid in your uniform child support order with a condition for your effective date, but parties still have to make sure that they help the friend of the court out by notifying the friend of the court, hey, this condition happened, and now my support is supposed to change per our order. So you don't have to come back to court necessarily. You can put in various provisions that will have a second support amount or a different support amount effective at a particular time.
Yeah, and I know we've addressed it in other memoranda through the Friend of the Court Bureau in the past. And it's exactly what they've laid out. You check at the top of the USO, the temporary order box. As Aaron said, you modify the language in paragraph 13, and you be specific about the preserving the right to go back to retroactively modify based off of the temporary order, but then also adding in provisions. And so we can work on getting some draft language out to you, Lisa. I think that would probably be helpful. And whether it's a second grid, like Aaron just mentioned, or second tier in the support order, or even language in paragraph 13 that essentially says, upon the friend of the court or the court learning of the condition existing, this order will enter as a final order. You probably still have the right for an objection in case something else has changed in the meantime. But I think that there are ways to deal with this that won't necessarily require a hearing on each and every case.
I also wanted to point out in the chat, we've had a couple of counties that have shared how their counties are handling the modifications. I know Genesee County and Oakland County have both put some details in the chat, and if other counties are able to do so, I do invite you to share that information, because the chat not only is available right now, but you will get the recording for today, which will give you access to the chat as well. So if you have something to help out attorneys in particular county, please feel free to share it. What about a parent whose income has been imputed? And now not only do they not have the income actually because it was imputed, but now it wouldn't even be possible for them to have that income should they so desire. Kent?
Right. I think both the federal regulations and the child support formula have been increasingly stringent on when you can impute income. The idea that you just don't like someone's choice and get a job really is not enough to impute income. And when income is imputed, you would have to really satisfy the requirements. If you go through the formula about all the things that you have to make sure of, including that there's a job actually available for someone, that their skills can match, and that they can get to that job reasonably.
Yeah, it's
That
really
is true.
all. Go ahead, Ken. Sorry.
Oh no, go on, Paul.
I was going to say, I mean, it's really tied to the actual ability to earn. and the likelihood and opportunity to earn and access that job. And Kent was touching on that with, can they get there even? And in a lot of the urban jurisdictions, public transportation is severely limited now as well. So, obviously everything is case by case, but it sure looks like there's a lot of reasons why, if they did have imputed income, they have the right, just like anybody else, to modify that order. That's just the income that was used based off of the ability analysis at the time their order was entered. There are, like I said earlier, Kroger and Meijer and others are hiring, but I think it's going to be severely limited in people's ability to actually access employment right now.
And so if you have imputed income as the basis of your child support, maybe this would be a situation where, and there's not an ability, even if you wanted to go get something else, you probably should do a motion to modify right away to get that temporary order in place at least. And who knows what the situation will be after, just because everybody gets to go back to their offices, let's say in a month, hypothetically, doesn't mean that those jobs that existed 4 months ago are going to exist 3 months from now. We don't know what companies are going to go away and what's going to be available for.
Well, and I think it depends on what was imputed. If it's imputed because they were, working fast food or something and those layoffs have hit, then obviously that opportunity is not there. But if they were imputed based off of some kind of self-employed work that they were doing and there was really no record of anything, so all that the court could do at the time was impute, maybe some of that work is still available in the gig economy, but it depends specifically on the case.
Yeah, the whole imputation analysis has changed dramatically from what we would have done 4 months ago. One of the imputation factors is the availability of an opportunity to work in that geographic area, and that's obviously dramatically changed depending on, the person's line of work. It could be that they have more opportunities to work than they did. I had another referee in our county had several hearings last week that involved people who were surprisingly still working overtime, working extra. So it kind of depends on the individual case, as Paul said, and what their, and the estimating income is different from imputing income, right? If you think that they are actually earning that, it's just very hard to nail down their income. That's more estimating their income than necessarily imputing their income. And that
Imputing is when someone is making a certain amount and you decide to use a different amount. If you're not sure what they're making and you're saying, I know they're telling me they're only making $100 a week, but I really believe that they're making $300 a week, that's estimating, that's not imputing.
Right.
Now, it might be an interesting question if someone historically has not worked, choosing to stay home with the kids, choosing not to work. I don't know that they can use this as a reason to say, well, now you shouldn't impute to me. So that would be an interesting question on what would happen with that.
Doesn't that happen a lot with let's just use a payee spouse who stays at home? And what I usually see is the courts imputing at least a part-time job of $10 an hour at a minimum. So how that affects the payees, like they couldn't even get that if they wanted to, but.
Right, so historically, if they haven't been working and now they say that this is a change in circumstances because even if they wanted to work, they couldn't, I don't know that would necessarily fly as a change in circumstances because they weren't working in the first place. So it really didn't change their circumstances. The fact that they probably couldn't find a job readily now doesn't really change their circumstances if they weren't working and weren't planning to work.
Well, and there's also the issue of people's perception of danger. If somebody is in one of the groups that is particularly at risk and decides that, you know what, I have a job, my employer is continuing to operate, but that amount of contact with the public puts me at increased risk of something that could be a really ugly and painful death. Do they still have to work? Do you say, hey, tough, you got to, you should still go out there and work? And those are issues that you always have to a certain extent, but they're, I think, highlighted now with coronavirus where it really is dangerous.
Right, that's a good point. We're not just looking at their line of work and the geographic circumstances, but do the children, do they have someone vulnerable in the household? Are they vulnerable? All of those sorts of things would be in the imputation considerations.
So another topic that we should at least address for a couple of minutes, but it is a huge can of worms and there's no way we're going to get through it all, is when the payor is a business owner. And, there's a lot of businesses that are shut down right now or working reduced and not having as many gross revenues. But there's also a lot of programs that are allegedly being made available to small businesses to help them stay, keep payroll and everything. So when we have, being a business owner as a payor is already, I would think, Aaron, Kent, maybe you can tell me, it's already pretty complicated when you're trying to figure out what the income is. And then how do we deal with this added uncertainty of when we're having to look at the business income, and that there's a lot of question marks with that, but also there's federal programs that they might be able to avail themselves to, which could generate income for the business as well.
Well, a lot of the programs are loans. And we were talking about this before about, for instance, if you take a withdrawal from your 401k and you have the ability to pay it back within 3 years. Well, technically it's not a loan, it's a withdrawal. And those are normally counted as income, except to the extent they've already been counted in your child support because we didn't take it out of your income, which is a tracing problem on its own. On the other hand, if people take a loan.
Put that in there, Kent. Were you involved in putting that for?
Well, I have a question, Kent. Is it considered income because you have 3 years to pay it back? Would it make a difference?
No, that's, I'm just saying it looks a lot like a loan. If you take a loan from your 301k, loans are generally not considered income. They can be if you're saying that it really is income, but mostly you don't include loans as income because you have to pay them back. But if you take a loan from your 401k and say, oh, that's not income, but if you take a withdrawal from your 401k with the intention of paying it back, is there really any difference, right? The tax status is a little bit different, but in fact, you're doing the same thing, but they're treated very differently under the formula. And so if you have a client that is looking at the two possibilities, you may want to talk to them about which one will be counted as income and which won't. For businesses that are eligible for loans, again, generally a loan isn't income because you pay it back, right? It's not true income. And so again, I think you're going to have to look at it case by case. Some small businesses are a mess anyway. In a sense, most tax returns are really just an affidavit, right? The people, just because they filed with the federal government and they've signed it, doesn't mean that it's really true. And I've had a couple of cases that I've arbitrated where a forensic accountant went through what was going on, and I was shocked at how much income there really, but again, I can look at a tax return and say, yeah, you add back in real estate depreciation, you add back in this stuff. But in this case, people were just basically lying about what their deductions were. And if the IRS was ever actually auditing these things, they would have been in some serious trouble. So you never know with a small business. It's always going to be a nightmare, and you just do the best you can.
So for example, with the payroll protection program, it starts off as a loan that basically is 2.5 times your payroll. But then you have an opportunity to potentially have it forgiven, but we're not going to know. First, we have to apply for it and get it. And just because that money comes into the business on day one, then you have to look at the next 8 weeks to see if how much of the loan can be forgiven. And then there's going to be a whole forgiveness process. So I think we're looking at many months down the road before we're going to actually know how much of a federal program can even be treated as income. We're not going to have the answers next week or next month. It's impossible.
Right. And I guess I'd make it the analogy similar to student loans is a great example, not getting into the whole forbearance stuff right now, but whether it's through a public service loan forgiveness or you reach your 20 or 25 years and the remaining amount can be forgiven. Well, at that point, you know, the IRS specifically says that, you know, that is taxable income, the forgiveness amount. And so I think the analogy is really similar here, where right now, as Kent's saying, it's treated as a loan. I think we have to expect it to be repaid. And to the extent that down the road, whether it's, you know, I don't know how quickly that forgiveness can start to kick in, or the eligibility even, but to the extent that an individual does get that PPP loan forgiven, then I think we would need to look at counting that as income. To the extent it's there now and it's used specifically for payroll, I mean, I guess the argument would be payroll or rent, that is specifically offsetting costs and creating more cash flow available for other things, creating more cash available from which to pay support. And,
right.
And I think that's, yeah, I mean, that's the argument, and that's the underlying objective of the formula, what's available to pay.
And presumably those businesses, in order to qualify for that PPP, they have to show that they've been economically affected. So they have negative effects that might be offset to some extent by grant programs. And keep in mind, it's not just federal, there are also local grant programs and small business association loans and grants and things like that that are going to, you will need to ask about. That will need to be something that you find out about when you're trying to analyze the support. But I don't know that it's necessarily going to be months and months, like 8 months before we know, because I was talking to Connie Thacker, has a financial expert, Troy Butler, and he said they're really getting, banks are trying to get answers to people within, he said, as short as 5 days, and the longest he had heard of was 45 days as to whether they got that loan. Now, what part of it gets forgiven? You know, he said June 30th is kind of where they're looking at how many employees do you have at that point? What did you use it for? And so you may have some answers by midsummer on what that bigger picture. And that's where we go back to the idea of a temporary order and putting in item 13. We can go back and fix this. We don't have to figure out the answer ourselves right now.
Yeah. Right. One thing that we should remember when we do temporary orders is at some point we need to clean them up, because my nightmare is like 5 years from now, somebody goes back and says, hey, you know, back in 2020, this order was a temporary order. I can go back to 2020. You can be, you know, 2027. Someone will go back and say, hey, I can still modify that order that was entered back in 2020. So if you do enter a temporary order, you should keep that in mind and either put some provision in what time frame it can be modified in, or later on in whatever subsequent child support order is entered to put some finality on the temporary order, because you don't, otherwise they're out there like little you know, traps for the unwary, and you'll want to pay attention to it.
Yeah, that's a good point.
Thank you, Kent, Paul, and Aaron. I think we're going to have a lot of more questions that are going to be coming out as different developments are happening, as we learn more about federal programs that parents might be able to avail themselves to, as we are waiting for the FAQs from SCAO on child support issues, and we expect there might be that administrative order from the Supreme Court. I just posted a link on the chat with a resource page that my firm has created that's specifically for family law attorneys. So anything that comes in that's really relevant to family law attorneys, I've just been trying to post it. It has, you know, executive orders and administrative orders and other things that are relevant to family law attorneys. So feel free to keep an eye on that. And as soon as something comes out, we will be sharing, adding it to the page. So I wanted to thank all of you for coming today. And I know we're going to have a lot more questions. So if you think of some questions right now that you have that we didn't get to, feel free to put them on the chat or email me, you know, anytime after, and I'll just start compiling the questions just to kind of have something to frame the next conversation. Because I think we've already agreed that the four of us need to come together again to talk about this once we have more information, because there's a lot of pieces of the puzzle that we're still waiting for, and the child support issues are going to be we're going to be dealing with them for a while. Let's just put it that way. So thank you, everybody.
Can I add something real quick?
Yeah, Aaron, of course.
So I saw your other webinars, and I think that one thing for practitioners to really keep in mind when we say, you know, your best bet is get your motion filed. Do that, but also try to work with the other party, because parties can reach agreement on these child support issues. You don't have to sit back and wait for the friend of the court or the court to have their hearing. If you are equipped with enough information to ask the right questions and get the income information and try to figure it out and put in those provisions about being temporary or being reviewed, or it'll be reinstated on this date. If you can create a good order that the parents can agree upon, you're probably going to come up with the most fair result and the best result for the kids by negotiating with the other party, rather than having the friend of the court make those decisions or the court make those decisions for you. So we always encourage people to get those stipulations in. Friend of the court offices will process them, and where we can do that, we're really in the best position to make sure kids are provided for. So
Yeah.
Great point, Erin.
Yeah, I was just going to add on too, you know, I think that's something we've been encouraging across any of these issues that have started to come up. And specifically here for support, those agreements aren't barred by that retroactive modification statute either. They probably would need to be entered as deviations. So just kind of a caution there on those. Because the formula manual is presumed to be the appropriate amount. So to the extent they agree to something else. But I think under the kind of the catch-all provision for anything else the court deems appropriate, I think we kind of fit under a pretty unique circumstance right now. So.
Erin, your point was really good, because you know, we might be able to help our parties negotiate some agreement. But when we can't and we can't get into court, we also have something called mediation. And I know Kent Waichman is a mediator, and there's a lot of other mediators that are on the call today. And just to give you a heads up, next week's webinar is going to be doing family law mediations via Zoom. So that's our topic for next week. But remember that, you know, maybe it's too high conflict for us to resolve it for our clients, but we do have a lot of really great mediators involved with the family law section, such as Kent, and to help with the process. And thank you very much, everybody.
Thank you.
Bye.
Lisa.
Bye.
Stop recording.